the Citizens' Rights Directive 2004/38, AIC and the 3 European Free Trade Association members, Iceland, Norway and Liechtenstein. Switzerland, which is a member of EFTA but not of the EEA, is not bound by the directive but rather has a separate bilateral agreement on free movement with the EU. It consolidated older regulations and directives, and extended the rights of unmarried couples. It gives EEA citizens the right of free movement and residence across the European Economic Area, as long as they are not an undue burden on the country of residence and have comprehensive health insurance. This right also extends to close family members that are not EEA citizens. After 5 years, the right of residence becomes permanent, which means it does not depend on any precondition any longer. The directive contains the following chapters. Pursuant to Articles 4 and 5 of the directive, any EEA citizen can leave his/her own country and enter another EEA state without a visa by presenting a valid passport or national identity card. If an EEA citizen is unable to present a valid passport or national identity card at the border, he/she must nonetheless be afforded every reasonable opportunity to obtain the necessary documents within a reasonable period of time or corroborate or prove by other means that he/she is covered by the right of free movement. The directive applies to any EEA citizen who is moving to and living in an EEA state other than his/her own. However, it also applies when a European citizen is moving back to his/her home country after staying in another EEA state, as defined in the case of Surinder Singh. For dual citizens with 2 EEA nationalities, the directive can apply in any EEA state. Temporary limitations are in place for the new member states of the EU. To be fully covered by the European right of free movement, the EEA citizen needs to exercise one of the 4 treaty rights. These rights are named after the Treaty of Rome, which defines the freedom of movement for workers. They have been extended over time, and are mainly of historical significance by now, since being self-sufficient has been added to the list as long as a citizen has sufficient money or income not to rely on public funds and holds comprehensive health insurance. He/she exercises one or more treaty rights. If no treaty right is exercised, the right of free movement is limited to 3 months. Family members are also covered by the right of free movement, but only as a dependent of the EEA citizen. The right is limited to the EEA state in which the EEA citizen is exercising treaty rights. In certain cases, the family member can retain the right of residence. A family member is defined as, there is a second category of extended family members, which can be included at the discretion of national legislation. It covers dependent relatives, dependent household members and unmarried, unregistered partners in a durable relationship. The right of free movement is granted automatically when the requirements are fulfilled, and it is not subject to an administrative act. However, member states may require the EEA citizen and family members to register with the relevant authorities. The relevant documentations are: permanent residence is acquired automatically after exercising treaty rights for 5 years, with absences of normally less than 6 months a year, a single absence less than 12 months in certain circumstances, or longer for military services. Permanent residence removes any restrictions that are in place concerning access to public funds, although some of these restrictions are already lifted after a period of 3 months. Permanent residence is only lost after an absence of 2 years. All applications covered by the directive are free, or require at most a moderate fee similar to comparable national documents. In Austria, the directive is transposed into national law mainly via the Niederlassungs- und Aufenthaltsgesetz. A credit card-sized plastic card is issued to document one's right. In Germany, the directive is transposed into national law via the Freizügigkeitsgesetz (EU), which could be translated as Freedom of Movement Law (EU). Not all mandatory sections of the directive are included in the Freizügigkeitsgesetz (EU). The applications are handled locally, together with the mandatory registration of residence. The EEA countries have had to implement this directive in full. In Norway, this was implemented by changing the alien law, which entered into force on 1 January 2010. In Italy, the directive has been implemented into Italian legislation with Legislative Decree N. 30 February 6, 2007. The applications are handled by the Comune of the city where the applicant takes his or her residence. In Ireland, the directive is transposed into the European Communities Regulations 2006 amended by SI 310 of 2008 in reaction to the Metok case and amended by SI 146 of 2011 allowing visa-free entrance with a residence card issued by another